moving to the third aspect of our today's session, which is on the appointment and challenge of the arbitrators. Now, Section 11 deals with the appointment of arbitrators. Section 10, before that, I think mentions about the number of arbitrators, that it does not have to be the even number of arbitrators. And the default rule is that if the arbitration agreement is not stating how many number of arbitrators there have to be, then there will be a sole arbitrator. Now, if there is a sole arbitrator, the only mechanism to appoint that sole arbitrator is for the parties to mutually agree on that arbitrator. Or you can have the resort to institutional rules where the institution will be appointing the arbitrator. You cannot unilaterally appoint an arbitrator. Earlier, various government contracts were allowing for the provision that the governmental agency or the PSU would be appointing the arbitrator by themselves, and that arbitrator would be deciding on the case. But that has been held to be invalid by Supreme Court, and the position is clear that unilateral appointment of arbitrators cannot take place. If there is a sole arbitrator, you have to mutually appoint that arbitrator, or you have to resort to institutional rules if the agreement provides for that, in which case institutions such as SIAC, if it is the one, or MCI, if it is the one, will appoint the arbitrator. This is the state mechanism for appointment of arbitrator. Now, what happens is, if you have a 3-member arbitral tribunal, usual mechanism is that one party appoints the arbitrator. The first party, like the claimant, will appoint one person. The respondent would appoint the other person. The two appointed persons would appoint the third person collectively. And that's how the tribunal gets constituted. Now, this is the usual case. But often there can be a case where there is a multi-party contract. Say, suppose there are 5 parties in a contract and all the parties have conflicting positions. So we are not taking a situation where only 2 parties are fighting or only 2 interest groups are fighting. We are taking a case where 5 interest groups are fighting and all parties have their own interest. In which case, if we have 3-member tribunal, then we will have difficulties. Why we'll have difficulties is because all these 5 people cannot really appoint one each. And they will not agree just because 2 people happen to be on the claimant side. They do not have the same interest, so they may not want to appoint together the arbitrator. If they can appoint the arbitrator together, it's fine. If they cannot, then of course all the members of the tribunal will have to be appointed by the court or the institution itself. You can read this landmark case of Decoding, in which case what happened is there was the claimant who had appointed the arbitrator. The respondents did not have the uniform interest; they had conflicting interest, and therefore, what the ICC has done is appointed all the members by themselves, and that was something which was upheld by the French courts. So this type of situation can also happen. Generally speaking, this type of situation will not happen. You will have 2 interest groups fighting with one another, and they will appoint one person each. Sometimes the 2 appointed people may not be able to come to an agreement, in which case Section 11 application will have to be filed. If you are not able to appoint a sole arbitrator mutually, then also a Section 11 application has to be filed. Now, the forum before which the Section 11 application has to be filed is either the High Court or the Supreme Court. No institution has been still so far given the power by these courts to deal with the appointment matters. So the courts are the ones which are dealing with the appointment matters. For the arbitrations which are international, Supreme Court has the Section 11 hearing ability. For the rest, it is the High Courts who hear the Section 11 applications. Now, under these applications, the scope for the court to look into is that the arbitration agreement exists. If the arbitration agreement exists, they go on appointing the arbitrator, and before the arbitrator, one can raise the defects or the objections which we had discussed a little before, which may be in the nature of jurisdiction or the arbitrability aspects. What also needs to be remembered is how Section 11 has to be filed. Or what are the certain tips that one needs to take into account while drafting a Section 11 application. Before Section 11 application can be filed, you will have to give an arbitration notice. An arbitration notice will have to be given. You will have to give a broad understanding of the disputes, broad understanding of the contracts. Say, suppose this is a sale purchase agreement which has been entered into by the parties. There were certain obligations which have to be performed by the parties. These are the obligations which have not been performed by the parties. And as a result, certain claims have arisen. And we have requested the demand of these claims, payment of these claims over time, but the payment has not been made. So, so in this slide, disputes have occurred between the parties. We refer to so and so clause of the arbitration agreement. And in terms of that, there is a sole arbitrator or a 3-member arbitrator, and we appoint our arbitrator, or we nominate this to be appointed as a sole arbitrator. That is what you broadly say in arbitration notice. You do not have to give your claims in totality in arbitration notice. You can avoid quantum also. You can say that the claims figures you will be giving at a later stage, and you can also mention that the claims which are mentioned in the arbitration notice are non-exhaustive in nature. You can raise them little afterwards also in statement of claim when the same is filed before the arbitral tribunal. So this is a broad aspect of arbitration notice. Once the arbitration notice is received by the other party, then the arbitration proceedings commence as per Section 21 of the Arbitration Act. Now, once the arbitration notice is received by the other party, it can either agree with the sole arbitrator being appointed by the other party, in which case there is no problem, or it can reject that, in which case there is a problem of how you arrive at the mutual agreement. If you do not arrive, then Section 11 has to be filed. If there is a 3-member, then the other party can reply, your member is this, and we are appointing our member as so and so. So, and then those two people will have to arrive at a third person set consensus. Now, if there is no consensus on the third person or on the sole arbitrator, Section 11 application has to be filed. The Section 11 application is a basic application where you will attach or annex the contract in which the arbitration agreement is contained. You will describe the contract. You will tell about various obligations that have led to this dispute, and what are few correspondences you have exchanged. Most importantly, you will touch upon the arbitration notice which is being issued by you. You will show that how this arbitration notice has been received by the other party, either by attaching the proof of the email or by attaching the delivery proof of a speed post or a courier or a registered post, or by showing that this has been replied to by the other party. Why you need to show this is so that the court can really know that this arbitration notice was in fact issued to the other party. You will show the reply which has been received by the other party to show that basically both the parties are not able to come at a consensus for the appointment of the arbitrator. And then you will have to request the court to appoint the arbitrator. Section 11 applications are basic in nature. You have to show that there is a dispute which has arisen, arbitration clause has been invoked, notice has been exchanged, if whether it has been replied or not replied, and you seek for an appointment of an arbitrator. Court is going to look into the aspect of existence of an arbitration agreement. And with that, the appointment of arbitrator would happen. Now, within that also, while the other party is filing the reply, they will of course like to show that either the arbitration clause does not exist or the disputes are not arbitrable. This type of issues they will try to rope in. They will try to take into account certain issues which can be taken before the court under Section 11, and in which scenario Section 11 adjudication may be a bit delayed. Now, this is the aspect on the appointment of arbitrator. We move to the second limb, which is the challenge of arbitrators. Now, before challenge, what we need to remember is that arbitrators, as soon as they are appointed, they have to disclose certain aspects. Those aspects include any circumstances which are likely to give rise to justiciable doubts as to independence or impartiality of arbitrators, as well as their ability to devote sufficient time and conduct proceedings in an efficient and an expeditious manner. Now, the Arbitration Act has a certain timeline for doing arbitrations under 29A. The arbitrators are supposed to disclose the number of matters or number of arbitrations that they are doing, so that it can be cleared, it can become clear if they are in a position to do this arbitration in an expeditious manner or not. The idea is that arbitrators should not be overloaded with matters in a manner that they are not able to give dates even in 6 months. Before this amendment came in, there were arbitrators who are very, very overloaded, and they did not have dates for 3, 4, 5 months. So that system has changed now, with the arbitrations getting over in a faster manner. The pendency has reduced, and the arbitrators have also started taking the arbitrations in a more serious manner and handling them in an expeditious manner as well. Now, naturally, if there are circumstances that give rise to justiciable doubts as to independence or impartiality of arbitrators, then you can challenge this. You can challenge the appointment of the arbitrator, saying that there are doubts as to the independence or impartiality of the arbitrators, or the disclosure which the arbitrator has given is incorrect. There are things which the arbitrators have not disclosed. What you can also say is that arbitration clause provides that the arbitrators had to possess certain qualifications, and our arbitrator does not possess these qualifications. So we want to challenge this particular arbitrator. The disclosure requirement is under 6th schedule. There are certain events which make the appointment of the arbitrator completely ineligible. There are 2 schedules which you should see, Schedule 5 and Schedule 7. One of this schedule prescribes that if the arbitrators have certain relationships within mentioned under those schedules, then the arbitrator would be completely ineligible to decide on your matters. And the other schedule points out situations which can give rise to the justiciable doubts. So arbitrators have to disclose all these events. These events can be what? An example could be where the arbitrator has a relationship with a client, or he has been appointed, he or she has been appointed as an arbitrator by that client in previous proceedings, or by the lawyers of that client in previous proceedings. That has to be disclosed. You would have seen Mr. Mehta's, Tushar Mehta's statement that on Bar and Bench a couple of days back. If you look at the lawyer or the law firm or the client's name, you can guess the name of the arbitrators. That was the statement that he has made, and that is something which has come in media. So you would see essentially that what the idea of the schedule is, that you cannot have one particular person being appointed again and again, and that you cannot, if you do that, then beyond a point, beyond certain limit, that person would become ineligible to act as an arbitrator. And the second way to go about is that if it goes beyond certain limits, then that would have to be disclosed, and that can lead to justiciable doubts as to the independence or impartiality of arbitrators. Now, of course, the lawyers are also smart. They handle those proceedings through multiple lawyers. They make someone else as a lawyer who is on the brief. There could be different lawyers who can be engaged. So sometimes, like say suppose ABC is the client, they will have the arbitrator appointed from the ABC rather than from the law firm. Sometimes the appointment letters go from the firm, in which case the firm's appointment would numbers would start counting up. So there are some ways to go beyond this also, but the idea behind this section and the schedules is that the arbitrators are the fulcrum, and if they are if there are doubts regarding their independence or impartiality, then the arbitration cannot be conducted in a smooth manner. Arbitration would be rigged, and that is something which will not inspire the trust of the parties involved. That would something which will go against the legitimacy of the system. So the idea is to ensure that the system remains legitimate, system remains unbiased and independent and impartial. So that is why these disclosure requirements are there, not just to have the arbitrators being independent, but also to see that they remain efficient. They have the time to devote to the arbitrations. So fifth schedule is the one which talks about the justiciable doubts. And seventh schedule is the one which picks out the circumstances, which says that if the arbitrator falls under these categories, then he or she would be absolutely barred from being acting as an arbitrator. The example of the seventh schedule is where arbitrator was an employee or a consultant or an advisor of a party, then he cannot act as an arbitrator. So procedure for the challenge under section 13 is effectively that you will have to challenge. Now, this is something which a question was raised before on the aspect of section 16. This is something which may seem a little odd to hear, but the challenge procedure is you will have to file written statement of reasons within 15 days of becoming aware of constitution of the arbitrator or the circumstances that led to the justiciable doubts, and that is challenge is something which is decided by the tribunal itself. So yes, tribunal is the one who is going to decide this aspect. Often members step down once these challenge procedures are being filed. If they do not step down, then they would be the one who will be deciding this. Then if the challenge fails, the arbitrator will continue, and the remedy would lie under section 34. If challenge succeeds, then the arbitrator would definitely will have to stand down. Now, section 14 also has certain resort that if the arbitrator were to fall under the category of ineligibility as described in section 14, then instead of going to the tribunal, you can straight away go to the court for the arbitrator challenge.